Mr. Mays from the 8th District Court of Appeals, and welcome, Judge. Thank you for sitting in with us. I'm going to then call Mr. Taft, who will be arguing first.
Thank you, and good morning, Your Honors. If it please the court, I would like to get right to the fundamental error that we believe occurred below in the Court of Appeals, where the court held that the First Amendment was not even implicated in this case, and they overturned the decision of the trial judge, finding that this targeted tax violated the First Amendment. And I think that the place to really start to look at where the Court of Appeals lost its way is to look at Minneapolis Star and look at the underpinnings for the rule of law that was set forth by the U.S. Supreme Court in Minneapolis Star. And really the guts of that holding and of the rationale for it is on pages 584 and 585 of the official opinion of that court. And that court went back and looked at the intent of the framers of the Constitution and the Anti-Federalists, the concern about a government having even the power to impose a targeted tax only on the press, and that the First Amendment was drafted with specific reason in mind of prohibiting a government from having the power to impose a targeted tax only on the press. And the Minneapolis court, the Supreme Court, specifically ruled that and this is what I think the Court of Appeals below missed, specifically ruled that the mere power in the government to impose a targeted tax on the press, only on the press, as opposed to a general tax, that mere power by itself inherently censors speech and will inherently cause a speaker to self-censor if the speaker knows that the government has that power. It inherently censors speech. But the court went further and it said, furthermore, if a government actually passes a targeted tax only on the press, that now there is a presumption raised that the government actually intended to control the content. And that is...
Also, can you tell me how the content is controlled by this tax?
The court in Minneapolis Star specifically stated that if a government has the power to issue crippling targeted taxes only against the press, and it's not constrained by the natural constraints you would have in a general tax, that will intimidate or place the speakers in fear that if they say something to offend the government or to criticize the government, that they will then be subjected to crippling taxes, which is, sorry.
But counsel, the tax occurred or is in place, and it has nothing to do with the content of your billboards.
The tax on its face applies to all messaging on billboard and all billboards. That is correct, but that misses the underlying rationale that the ability to target only media, only the billboards, that inherently controls speech and censors content.
Why?
Because
why does that censor content? How does it censor content?
Because, as the court explained, if you know that if you criticize the government, that the government can pass targeted taxes on you, you are going to self-censor. That is
Can you criticize the government by skywriting or handing out pamphlets?
Sure. There are lots of different ways to criticize the government. But as Minneapolis Star, remember, that was a tax only on the ink and paper used to produce newspapers. It was totally content neutral. And yet the court held that the mere power to pass a targeted tax only on the press, that inherently censored speech.
Excuse me, counsel. Is the issue here that there's only a few number of billboard companies, or that it targets one part of the press? could the state of Ohio put a tax just on cable TV stations?
No, they could not. It offends both. And again, Minneapolis Star.
Hold on. So the rule that you think it's anytime any part of the press is targeted? Just help me understand because Minneapolis Star, there were of course two issues. One was that it targeted the press. The other was that it targeted a small number or part of the newspaper industry. So is it, help me understand what the rule is. Is it anytime it does either one of those things, or does it have to do part of, does it have to be a small number of market participants? What's the determinative factor here?
The rule is either one. The test and the black letter law test, if you look at the very last sentences of the ruling of the opinion in Minneapolis Star, it sets forth that the test is clear as a bell. And that is a tax that targets only the media violates the First Amendment unless you can meet strict scrutiny. Actually it's not an and, it's an or if you target a small group within the media. Then you also violate the First Amendment unless you meet strict scrutiny. And when Leathers came along,
they don't really say it's a strict scrutiny standard, do they?
Yes, specifically. They say it's a strict scrutiny standard. You have to show a compelling reason and that it's narrowly drafted.
Well, what I read it saying is a counterbalancing interest of compelling importance that it cannot achieve without differential taxation. Maybe that's equivalent to strict scrutiny, but I'm not sure that.
I think you're right where you're reading from. Yes, you're reading actually from the pages that I cited, and that is strict scrutiny. And then Leathers came along, and Leathers upheld.
Counsel, let me ask this question. You're stating that the tax is on the media or the press, but this tax and the press is then, they're the ones making this speech. In this case, the speech is from a third party. So how is this, affecting your billboards when the speech is from a third party and not like the press where the speech actually comes from the press?
Yeah, there is ample authority out there that it doesn't matter if you're saying that you're taxing the provider of the speech or if you're taxing the third parties. There's a Supreme Court case involving a publishing company that publishes the books of others. And that issue was raised and the court held, it's in our brief, and the court held that it doesn't matter that you're disseminating the speech of someone else. You have full First Amendment protection as the publisher of someone else's speech. Keep in mind, when the U.S. Supreme Court in Metro Media held that billboards were a traditional, venerable medium for the presentation of political, social, and other non-commercial ideas, he has full First Amendment rights of protection. Billboards were doing the same thing back then as they're doing now, except they're doing more non-commercial now. And the Ohio Supreme Court in the Norton case said that billboards are in a category where they present pure speech, which is entitled to an even higher level of protection of speech. And there have just been, when we cited them in our briefs, there have just been numerous cases where someone claims, well, it's on the business of selling advertising. That has not gotten them around the First Amendment. There are cases like Minneapolis Star where they tried to get around the First Amendment by taxing the means or instruments for producing the speech, ink and paper. Here, the city has claimed we're just taxing those billboards, those wooden structures. And those specifically are the means and instruments for exclusively used for the production of speech.
Mr. Taft, Mike Galasso for Norton Outdoor. I wanted to get in on the remaining 6 minutes based on our division of time.
Thank you.
Counsel, you're not controlling pace of the argument. Mr. Taft is
Understood.
finished, then you can have your turn, okay?
Okay. Thank you, Your Honor.
Mr. Taft?
What I was getting to is that the actual holding in Minneapolis Star itself was that even taxing just the means and instruments used for the presentation of speech, that itself was the same as taxing the speech. So we've seen book publishers who publish purely the speech of others. You look at the amicus briefs and the newspapers who came in. When have you ever heard of the newspapers coming to the aid of billboards? But they came in their amicus brief and said they publish much speech of others. But it also disregards the ruling of the trial judge below. He said, yes, most of our messages are speech of others. That has First Amendment protection. But the trial judge specifically found on the evidence that both Lamar and Norton published a sufficient amount of their own non-commercial and commercial speech to qualify for First Amendment protection. So,
Thank you, Mr. Taft. Thank you.
yes, ma'am. Thank you, Your Honor.
All right. Mr. Galasso?
Your Honor, I'd like to reserve for rebuttal. I had intended to break the time into 3 minutes and then 4 minutes for rebuttal. Can I still do that?
You can proceed, and I'll give you, depends on how much time you use.
Okay. Well, I'll speak very briefly then, Your Honor. I'll speak for less than 2 minutes and then just reserve the remaining time for rebuttal. I just wanted to briefly address issue number 2, which is the gag provision and why that is not a moot issue.
Excuse me, Counselor. How is there any standing to appeal that? I mean, the rule is that you have to be aggrieved by a judgment in order to have standing to appeal. You seem to think you're aggrieved by the reasoning of the opinion, but you're certainly not aggrieved by the judgment. It was in your favor.
Yes, Your Honor, it was in our favor on the issue of the injunction, but we still have the claim below for damages. And so it's just our position that, criticism of the government is the most fundamental form of speech.
You have the claim below for damages, but you've already got the law repealed. So nothing we do here is going to affect your claim for damages.
Well, as things stand now, Your Honor, there's precedent that would stand unchecked in the first district where people that engage in truthful, non-misleading speech
but before you get there, is there any precedent that allows you to appeal a judgment that's in your favor? I think the answer to that is clearly no.
Well, Your Honor, we're only appealing it as to the remaining piece that was not rendered moot by the repeal 2 years later. That only would relate to the injunctive relief. So the court would still need to adjudicate the damages claim. And so with that, though, Your Honor, I would just reserve my remaining time for rebuttal.
All right. Thank you. Mr. Haynes.
Madam Chief Justice, and may it please the court. Contrary to what you have just heard, there are sound reasons why the court should affirm the constitutionality of the City of Cincinnati's tax on business privileges authorizing rental billboards. First, billboard operators are not engaged in speech and do not function as the press when they rent out their billboards. Second, the city's tax regulates billboard operators' economic activity, not their speech. And finally, the city's tax is not like those taxes that were invalidated in the United States Supreme Court's press tax cases. The court reviews these constitutional questions de novo, and the challenged legislation carries a presumption of constitutionality, even though it is challenged on First Amendment grounds. So first, when billboard operators wield their business privileges, they are not functioning as speakers or members of the press. Their business purpose is not to engage in protected expressive activity. They're not generating or selling content, serving as a government watchdog, or otherwise expressing themselves. In their own words, from trial, they sell product from their inventory to their customers.
Isn't that essentially what cable TV stations do and many other members of the media? They sell advertising, they sell product. I mean, the Supreme Court has never said there's a distinction, have they?
Well, Your Honor, two things. First of all, billboards are different from cable operators in that the cable operators tend to aggregate channels and make different offerings of content to customers. depending upon who you choose, it comes with different channels.
Okay, that's a difference, but is that a distinction that matters for the First Amendment context?
Well, I think it does, Your Honor, because in this case, billboard companies are simply selling space. There's no message or expression associated with it.
They sell space that expresses a message. That's what they do. Sometimes they're their own messages, sometimes they're other people's, but they're expressing a message. Certainly, that's what the First Amendment protects.
Well, and Your Honor, the United States Supreme Court has held, first of all, that each medium of speech must be regulated according to its own unique aspects. And in the case of billboards, there's long been a dichotomy that was first recognized in the Metro Media case between the non-communicative and the communicative aspects of billboards. So in some cases, in some mediums where those two aspects may be more closely aligned, they're more clearly distinguishable here. And
well, but to me, it doesn't that mean that cities has wide discretion to regulate things like the size and location, but here, when you're talking about a rule that forbids the government from singling out a particular part of the press for differential treatment, you're talking about the communicative aspects of billboards.
Well, Your Honor, I think, again, there may be regulations that apply to the non-communicative aspects that could have some impact on the communicative side, but certainly not direct, and certainly not here. These are economic regulations, and the United States.
If someone runs a billboard campaign criticizing city council, I mean, isn't it foreseeable that city council might decide that, you know, these billboard companies ought to pay a higher tax? Isn't that exactly what the Minneapolis Star case was about? Those kind of dangers.
Your Honor, first of all, in the billboard context, I don't think that that's carried out by the record. The city has long possessed certainly the police power to regulate billboards, including by
Minneapolis Star said you didn't have to have particular facts in the record, right? That was kind of, you don't have to have legislative intent. You don't have to have evidence of that.
Well, if you look at Minneapolis Star, Your Honor, you know, the tax in that case was what was termed a special tax, and I don't believe it was a special tax simply because it applies to newspapers. It was a special tax in how it was created and applied to newspapers. When you look at the tax in Minneapolis Star, even though they termed it a use tax, it wasn't in actuality a use tax, which caused it to be suspicious.
Okay, Council, let me ask a slightly different question to understand the ordinance. If I have one of those trucks that carry big billboards that light up and I'm at a summer festival, is that taxed by this excise tax?
No, Your Honor. Those trucks are not regulated by the zoning code or by the city's business.
So some billboards are taxed and some aren't, by whether they're mobile or not. Is that right?
Your Honor, the city's current regulations do not tax mobile billboards, but I think that is a unique issue that is not before the court, has not been developed, and is a unique problem within the area of the law of billboards.
Well, I'm trying to figure out similar ownership, similar, you know, who you're targeting, that issue. So who is the city targeting? Just stable billboards? They're singling them out?
Your Honor, it would be billboards that are planted in the ground, but primarily those who hold a business license from the city under Chapter 895 of the city's municipal code. And
so council, if a business had their own billboard on the side of their building or in their parking lot or whatever, are they covered here?
No, Your Honor, they do not incur tax liability because it's the economic transaction that gives rise to tax liability. The signs, it's because the signs are placed into commerce that they trigger tax liability.
Okay, what happens if they're advertising for somebody else?
Again, if it has to be economic activity in exchange for compensation. So if someone wants to promote someone else's ideas, there's no sale of space. Someone is just making.
So it's the sale of space that is what you're focusing on.
That's correct, Your Honor. These billboards, again, billboard operators, by their own words, operate akin to a rental company. These are essentially rental properties, and you know, going back to Justice Fisher's point, these are real estate. These are real estate transactions, and you know, they're distinguishable from those mobile vending operations in that they're taxed differently because, you know, they're fixed to real estate.
But you also have a size restriction. So if your billboard is smaller than X, you are not taxed, but if your billboard is bigger than Y, you are. Is that right?
Your Honor, there is an exemption for signs under 36 square feet, but it doesn't apply to any particular billboard operator. And then the amount of the tax, the minimum tax, is established by simply the size of the billboard, but it doesn't operate based upon the identity or the message conveyed by the billboard, and it applies across the board. So it's really up to the billboard operator to determine, you know, the extent to which they use their privilege.
Well, let me ask it this way. So if a citizen of Cincinnati owns a billboard and puts it up, you're saying there's no tax, right?
Correct, Your Honor.
But if the same citizen owns Citizen LLC and has to pay its own LLC for business purposes to put up the same sign, it's taxed.
Yes, Your Honor. The city doesn't make a distinction, but you know, you're talking about two different persons. And if a citizen elects to create a corporate entity, you know, they've established a separate identity and engaged in a transaction that you know, may give rise to tax liability in other instances as well.
Okay, well, let's assume that a PAC, a political action committee, buys some billboards, and I want to advertise on them. Does that PAC have to pay this excise tax?
Your Honor, if they own the billboards and are presenting the message, then no. But if they're selling the space to you or Procter & Gamble to sell Tide, or for any other purpose, it's the underlying economic transaction that gives rise to the tax liability. It has nothing to do with the identity of the speaker or the messages that they're seeking to convey.
Council, and because they have this cap and replace, then they're just boxed in. There's no way for them to get out of this tax because you also have the cap and replace for these billboards. Is that correct?
Well, Your Honor, you know, I would say that the cap and replace doesn't necessarily trigger tax liability. It creates, you know, a limited number of persons who hold these business privileges in the city. But again, the extent to which they put those business privileges to work is largely up to the billboard operator and the privilege holder. So I would also like to point out that the tax does not target a small group of speakers in the way that the infirm taxes in the United States Supreme Court press tax cases.
How does it not? It targets two speakers.
Your Honor, first of all, that it is not established in the record that it only targets two speakers.
Well, I mean, it is in the record that there's two speakers who dominate the market, right, in Cincinnati.
Yes, Your Honor. There are, however, many more billboard companies in the city. It happens to be that a small group may pay the bulk of the tax, but the city's tax itself is broad-based and applies to all operators equally and to each sign. equally determining upon its size and placement and nothing else. And when you look at the taxes that were at issue in the press tax cases, you're talking about taxes that were designed to narrowly target a small group and only the largest group of taxpayers to the exclusion of all other taxpayers.
Well, as I read the Minneapolis Star case, it seems to say that both are independent reasons for finding the tax unconstitutional. That it targets a segment of the press and that it targets a small group of speakers. It doesn't seem to say that it's only because it targeted a small group of speakers.
Your Honor, I would agree that both in Minneapolis Star and later in Leathers, that either one of those could potentially be a basis for applying heightened scrutiny. However, as was explained in Leathers, I think you have to understand the greater concern within which those bases arise, and that is that the court is concerned when taxes have the ability to suppress the expression of particular ideas and viewpoints, and further.
Well, but why isn't that the case here? I mean, you already have a closely regulated industry by city council. I mean, I think there are indications in the record that you had various times city council members calling billboard operators about the content of their message. Why isn't there even a much stronger ability in a city like this for council to use the tax power to exercise the to control or influence communicative aspects of billboard operators than there were in the press cases? To me, it seems even greater risk.
I would say, first of all, Your Honor, under Ohio law, excise taxes cannot be raised to crippling levels. The Ohio Constitution forbids it. They have to be tied to.
Well, but that's not the only danger, right? I mean, it could be that maybe they're really happy with them and they lower taxes, or maybe maybe it's not crippling levels, but some other level.
Well, Your Honor, I think also I go back to the history, and there's no demonstration here that the fact that one council member at some point contacted the billboard company has ever actually resulted in any legislation.
It would seem like that would be a decent argument if it wasn't for the Minnesota Star case saying that you don't need that evidence.
Well, Your Honor, again, you look at the taxes, and it was a suspiciously designed tax that didn't have parallel in the state, whereas excise taxes are common throughout the state of Ohio and within the city of Cincinnati. And also, you look at how that tax was designed. It was designed in a way that the court said it resembled a penalty on the largest actors, and that's not the case here. This is an evenly applied tax that applies to effectively all within the industry. There's absolutely nothing in the record to show that there's anyone who wouldn't any billboard operators who wouldn't pay tax.
Council, is Cincinnati the only municipality in Ohio that levies this tax?
To my knowledge, Your Honor,
Okay.
It is the only one.
All right, Council, your time is up.
All right, thank you, Your Honor.
Thank you. All right, and Mr. Galasso, are you responsible for the rebuttal?
Yes, Your Honor.
Okay, you've got 2 minutes left.
Okay, thank you, Your Honor. What I'd like to do with the remaining time is first touch upon some of the questions that were just asked by Justices Kennedy, Fisher, and yourself, Your Honor, about the application of the tax. And it's not just on economic transactions or economic activity. In fact, the city calculated the tax based upon the minimum square footage. So if there's a billboard in the city of Cincinnati and it displays no message, or it displays a message that is completely unpaid, if that billboard has a permit, then it's going to pay the tax regardless of whether there's an economic transaction. And that brings us to the whole point of this case, and that it is true that billboards are a business, but they are a speech business in the same way that many speech businesses are businesses. And the amicus brief points this out very well. The Cincinnati Enquirer doesn't have a lot of its own content either, and contains a lot of syndicated content. It relies upon advertisements. And under the holding that the First District promulgated here, there is no reason that the billboard tax could not be selectively applied to newspapers, just like billboards, because they are also engaged in the speech business. And so this court has held in Norton Outdoor Advertising versus the Village of Arlington Heights in the 1980s that billboards are, quote, pure speech, that they are not just commercial speech, and that they are afforded full First Amendment protections and can't be relegated to a lower class of First Amendment protection. There's a similar holding from Metro Media from the United States Supreme Court that recognizes that billboards, while they may be subject to non-communicative regulation, are nonetheless afforded First Amendment protection. So you have to start from there, and to craft exceptions to avoid constitutional protection of free speech starts the erosion of those protections. And if it starts with a billboard tax, there's no reason that it can't apply to all the other amicus that are concerned in this particular case. So one of the quotes that I found interesting is that, and this is from Justice Hughes in Lovell versus City of Griffin, Georgia. It says, the liberty of press is not confined to newspapers and periodicals. It necessarily encompasses pamphlets and leaflets. And it says the press in its historic connotation comprehends every sort of publication which affords a vehicle of information and opinion. So billboards enjoy this First Amendment protection. You cannot separate the speech from the business, and it doesn't require an economic transaction. To allow this to stand, this court would have to reverse itself on the Village of Arlington Heights, would have to distinguish Metro Media, and would have to ignore Grosjean and Minneapolis Star in order to uphold a selective tax only on billboards.
Thank you. Thank you, gentlemen. We'll take the matter under advisement. You'll be notified of our decision.
Thank you.
Okay, I'll see you all later.
Thank you, Judge.
Thank you.
All right, our second case this morning is 2020-721, the State of Ohio versus Catherine Wilson. For the appellant, Mr. Vogt.
Good morning, Your Honors. Chief Justice O'Connor, at this time, I'd like to reserve 3 minutes for rebuttal.
All right.
Your Honors, the plain language of Revised Code 4511-01-HHH clearly indicates that that does not apply to the offense of driving under OVI suspension. Additionally, the legislative history of Revised Code 4510.14 demonstrates that the General Assembly assented to the continued application of the Cleary-Gill definition of operate for that offense. As to the first part of my argument, Your Honors, as this court knows, if the statute plainly and unambiguously expresses the intent of the legislature, there's no need to resort to any other means of statutory interpretation. And that's possible in this case for 4511.01, where the preamble contains the language as used in this chapter in chapter 4513. So by that plain language, it only applies to chapters 4511 and 4513, and therefore doesn't apply to chapter 4510. The second district noted this distinction in 2 cases, the State versus Cochran, the City of Dayton versus Ahmad, and then further City of Dayton versus Ahmad in paragraph 61. They upheld a conviction for driving under suspension, referencing the Cleary-Gill definition of operate by stating the person was in the driver's seat with possession of the ignition device. The other plain language we'd ask this court to take a look at is the definition of operator contained in 4501.01x. And 4501 is a definitional section that applies to most of Title 45, and specifically in its preamble that applies to Chapter 4510. And it defines operator as anyone who drives or operates a motor vehicle on the roadways in the state of Ohio. And you do see that language about driving or operation in other places in Title 45. I apologize, it's not in my brief, but Chapter 4549, Sections 08, 11, and 12, they all have that language with regard to driving or operation. And those are offenses of driving with improper license plates. So, Your Honors, the first part of the state's argument obviously boils down to a pretty simple plain language argument that based on the plain language of 45.
If you're going to make a plain language argument, and you don't have a term that's defined, why wouldn't you just start with the definition in the dictionary of what operate means, rather than try to pick out some definitions that by their terms don't apply in this statute. I mean, and why not just argue that operate means exercise control over, and that's the vehicle, and that here the vehicle is running, so he was operating it.
You know, I think my answer to that question has to do with sort of the second part of our argument, and that is the presumption that the General Assembly is aware of previous.
I'm trying to help you out here, but
I appreciate that. Well, I think the answer to that is because the General Assembly was aware of how Cleary-Gill was being applied in the context of driving under suspension statutes. In both my brief and that of the appellee, we cited this court to about, I think, 7 cases where Cleary-Gill was applied to driving under suspension statutes prior to the enactment of Senate Bill 123. And where a legislature reenacts a statute, they're presumed to have adopted all those previous interpretations as well. And page 8 of my brief, I talk about the previous version of driving under an OVI suspension, 450702D2, and it's basically identical to the same version today, Your Honor. So there's no question that the General Assembly was aware of how Cleary-Gill was being applied in the driving under suspension context, and when it reenacted 450702D2 as 4510.14, it's our position that they adopted all those previous constructions of Cleary-Gill for driving under suspension offenses.
do you think Cleary was rightly decided? I mean, can you really operate a vehicle when it's not on?
I think so, Your Honor. I think the text in that opinion about operation is a activity that encompasses a broader course of activity than just driving. I think that.
Well, but it wasn't just driving. There wasn't. I mean, I don't think any speaker of the English language would say that someone's operating a vehicle when they're not exercising, when they're not running it or driving it or running the radio or anything, right? I mean, that doesn't seem like operating a vehicle to, unless you are completely divorced from how people actually talk.
Well, Your Honor, I think if that were the case, then 450101X would need to be revisited as well. If driving and operation were the same thing, there wouldn't be.
Well, it doesn't necessarily driving an operation. I mean, I would think that someone can operate a vehicle, at least under a common understanding, without moving it. I mean, you can run the heater, you can turn the radio on, you can do other things, but it's hard to say if you're not at least engaging the engine at some point that you're actually operating that vehicle.
I think I think the definition of operation in Cleary-Gill, I think was correctly decided, Your Honor, as it applied in the physical control statute. Person is operating a vehicle if they're in the driver's seat, possession of the ignition device. I think this court's decisions in Cleary-Gill were correct. But I'd like to just touch upon the fact that 4511.194 and 4510.14, all of what we're talking about today was addressed in Senate Bill 123. And as I stated, there's no question that Cleary-Gill, the General Assembly was aware of that in Senate Bill 123. I think that's obvious. And from the state's perspective, really the only thing that Senate Bill 123 changed was it specified that when a person is in physical control of a vehicle under the influence versus when they're operating or, causing movement of the vehicle under the influence, that they're guilty of 2 different misdemeanors of the first degree. And that's really it, Your Honor. So contrary to the dissent below the majority below and the dissent in Gill, I don't think the General Assembly had any concerns about the potential overbreadth of Cleary-Gill. They codified it into physical control. And because they were aware of how it was being applied in the driving under suspension context and they declined to weigh in, this court should not read that into the statute because it's just not there.
Counselor, you're saying, when in 2004, the General Assembly specifically defined the term operate under 451101HHH, meaning to actually drive, correct?
Yes.
So, and in the same act, they created the having physical control while under the influence.
Correct.
So in this case, So the problem here is that 451101 explicitly states that the definitions contained therein apply to words as used in chapters 4511 and 4513. Notably, this doesn't include 4510, which contains the driving under suspension statute in the case. And the term operator is defined in 4510 as operator includes any person who drives or operates a motor vehicle upon public highways.
Yes, Your Honor, that is my point. I think the plain language is the state's strongest position. You see that phrase drive or operate throughout Title 45. So it's clear to me that the General Assembly, when it weighed in on Title 45 and Senate Bill 123, by the virtue of the fact that it left that language in many places, that it still draws a distinction between driving and operating a motor vehicle.
So what you're saying here is that operate for OVI means actual movement of the car, and that for 4510, for 4510-14, which can't even be violated unless a person has already violated 4511, operate means simply being in the car with the key in the ignition.
That is correct, Your Honor, and that's pursuant to this court's holding in Gill. Operation is found when a person's in the driver's seat in possession of the ignition device, whether or not the car is running.
You don't think it could be legislative oversight to not expressly state in 451101 that the definitions used therein also apply to 4510?
No, Your Honor. I think that would assume that the General Assembly intended to act but failed to include the necessary language to do so. I think the other problem with that kind of interpretation is it would essentially add the word 4510 to the preamble of 4511. So as it reads now, it says, as applied in this chapter in 4513, that kind of interpretation would essentially have it read as used in this chapter, 4510 and 4513. So it add language, which as this court knows, it's not permitted to do.
But you do concede that this court has never decided the meaning of the term operate as applied to chapter 4510. You have no authority for that.
That's correct, Your Honor. Fury Gill was plainly about OVI. But my point was that the General Assembly was aware of how it was being applied in the context of driving under suspension charges. It would seem both the appellee's brief and mine support that the General Assembly knew it was being used in that context by virtue of readopting 450702D2, that it sent it to the continued application in that regard.
Mr. Vogt.
Yes, Justice.
Does it matter if the keys are in the cup holder or do they have to be in the ignition?
I think the wording of physical control, the Gill definition as it is applied, is possession of the ignition device. So I think the answer to your question is no.
Let me ask it a different way. A lot of cars now, you don't have to put the key in the ignition. You just hold a little key fob, right? So if the key fob's in the cup, is that operating?
I think so. Again, I think that's possession of the ignition device if the person is in the driver's seat, pursuant to this court's definition.
Okay, thank you.
Let me ask you about another aspect of the statute. No one's talked about. The definition defines it as operating on the public roads. What does that mean? And was that satisfied here?
Yes, Your Honor. I think the record reflects that Wilson was asleep behind the wheel of the vehicle in the driver's seat with the engine running, parked on the roadway on Pandora Avenue in the Pleasant Ridge neighborhood of Cincinnati. So yes, that was satisfied.
Okay, so if it was in a parking lot, it wouldn't be illegal. Is that right?
That's correct, Your Honor. Whereas OVI contemplates, I think the person can commit the offense of OVI on public and private property. This section is specifically limited to public roadways.
Okay.
Just another point I'd like to
follow. Can I just ask quickly, from a policy standpoint, isn't what the appellee did in this case exactly what we want? I mean, don't we want people who feel incapacitated or unable to drive? Don't we want them to not drive, and if there is no place to be, at least be in the safety of a car? And if it's wintertime, are we expected to have them sit in a freezing car rather than try to make it home and drive intoxicated?
Justice Stewart, just to answer your question, I see that I'm eating into my rebuttal time. I think that when the General Assembly enacted 4510.14, just the facts of this case that Ms. Wilson was asleep behind the wheel at a location nowhere near a place for which she had privileges to travel after what the majority characterized as a night of partying, I do not believe that the General Assembly intended for people who have been convicted of an OVI to engage in that type of conduct for policy reasons. So unless there are any other questions, I've reserved the remainder of my time for rebuttal.
Thank you.
Thank you.
Mr. Hoffman.
May it please the court, Chief Justice O'Connor and Associate Justices. I represent Ms. Wilson, and she's convicted of driving under OVI suspension under 4510.14. That statute has as an element operation, and the fact that we're arguing the meaning of that element before this court indicates that there is ambiguity with respect to that element and that the rules of statutory construction should apply.
Counsel, would we have to overrule Cleary or Gill to affirm?
I'm sorry, I didn't hear the first part of the question.
Would we have to overrule Cleary or Gill to affirm?
No, it would not be necessary.
Why?
Because it would be helpful but not necessary, because the statutory amendments in 2004 cover everything. You have actual driving that applies to 4511. You have physical control, and the Cleary-Gill definition of operation for the offense of physical control of a motor vehicle while under the influence of alcohol. And so my position would be that you can read 4511.01 triple H together with 4510.14 and achieve and ascertain the legislative intent that actual driving is required.
So we should assume that when the legislature said that this definition, this new definition applies to this specific statute, they didn't really mean that. What they meant was it applied to other statutes as well.
Are you referring to the statutory definition of operation, Your Honor?
I am the new definition that by its terms does not apply in this section. I guess that's why I'm struggling with how, when the legislature has passed a new definition, has said explicitly what section it applies to, why we would think that they meant for it to apply somewhere where they explicitly did not say it applied. You think they just made a mistake? You think it was an oversight? You think that they just thought we should kind of figure it out on our own? That's what they really meant. I mean, it would seem easy enough to put the section number it applies to if they wanted to change it.
The statement at the beginning of the definition section just says that it applies as in this chapter, as used in this chapter and in chapter 4513.
So
and it does tend to indicate that it would apply just to those chapters, but every definition section in the revised code reads that way.
Right.
And in pari materia, it doesn't.
Definitions apply to the chapters they say they apply to, not to other ones.
That's what it means. It means it doesn't apply to it means it does not apply to 4510. That's right. But that doesn't prevent the court from reading that statute with 4510.14 to ascertain the legislative intent with respect to the element of operation in 4510.14.
Do we then have to ignore what your colleague was talking about, 4501.01X?
I'm sorry, you have to remind me what that is.
That says that any person who drives or operates a motor vehicle upon the public highways is an operator. So it separates drives from operate. So if your analysis is correct, if we have to read all of them, don't I also have to read 4501.01X? Shouldn't I include that?
I'm sorry, I cut you off at the very end.
Should I not include that definition in the analysis?
I think you should not, because it kind of contradicts the language, the context, the statutory context in 451014 for that use of the word operate. Because in that statute, the title of the offense is driving under OVI suspension. It uses the word driving to name the offense, which would tend to indicate that driving is involved in the violation. And also it uses the word driving in the penalty section interchangeably with operation, which would tend to indicate that they mean the same thing. And I think that this contextual analysis is more direct than a possibly unrelated definition in 4511. So that would be my answer to your question.
Thank you.
And so that did introduce the first of the three rules of statutory construction that the Court of Appeals properly relied upon in determining legislative intent with respect to the element of operation in 4510-14. The second rule was the impari materia rule, which says that statutes that pertain to the same matter or subject can be read together to ascertain legislative intent. And irrespective of the preamble to the definition section in 4511, this court actually read 4511-01 H together with a statute in Title 27 to understand what the legislature meant in that in 274402 B1, which was an exception to the immunity provision for the negligent operation of a motor vehicle. And when this court read those two statutes together, it held that operation in that Title 27 statute meant actual driving and moving the motor vehicle. And so the preamble to 4511 did not prevent the application of that doctrine. The doctrine just allows, you're not importing the actual definition. It's just an aid in understanding what the element means. You're not violating the preamble.
Well, what if we just focused on the plain language, what an ordinary person would think that operation means? If I ask 10 people in Pleasant Ridge, what if someone's operating a vehicle, if they have the keys in the ignition, the engine running, is that operating a vehicle? What do you think they'd say?
I think unanimously they'd say it's not operating a vehicle.
You don't think running the engine of a vehicle is operating it? I think that's.
If I were a farmer and I was paying somebody to operate a tractor, if they're just going to sit there with a tractor and not move it, I would say they're not operating it, and I wouldn't pay them.
Okay, that's it. I like that answer, Mr. Hoffman.
Thank you.
Mr. Hoffman, so going back to Cleary and Gill, I think what I heard you say is that they've been superseded by statute because they were decided in the context of OVI, and the broad definition they reached was a product of that context. But since then, the legislature has superseded that. But still in superseding it, it didn't give us a definition of operate specifically for this particular situation. So is it fair for us do we reach back to Cleary and Gill, even though it's been superseded, or do we go ahead and try to look at 4511.01 H and say maybe that's what we can ascertain the legislature meant? I mean, how can you sort of put that in chronology for me and how you would suggest we do it?
Yes, Your Honor, thank you. Actually, it leads to this third rule of construction that I'd like to talk about now. And that has to do with an examination of the purpose for Cleary and Gill and McGlone. In those cases, those were OVI violations, and driving under the influence presents a special risk to the public of an intoxicated driver. And it's because of the purpose behind that offense that this court came up with a definition of operation that was broad. And it had to do with the potential of movement of the car. The fact that a person that's intoxicated in possession of the ignition keys, seated in the driver's seat, presented a special risk to the public almost as great as the offense itself. And so that was the reason for the operation definition in Gill and Cleary. Now, that same risk is not presented by the offense of driving under an OVI suspension, because intoxication is not an element to the offense. It's just driving during the period of suspension is all it is. And so because there's a different purpose to the statute, I think that's the reason why the Cleary, the case law definition of operation should not be looked to understand what the legislature was trying to say in using the word operation in the driving under OVI suspension statute. Instead, the court should look to 451101HHH, which is the common understanding of operation, which is actually driving the motor vehicle.
Let me go back to Justice DeWine's question about operation. If I'm in a factory and I'm running a machine, and I have to stop it for a minute to pull something out, but it's still running, but it's just not producing anything, am I operating the machine?
I would say no.
I would say yes.
Okay.
But doesn't but your example about the tractor and the example about the machine, I'm assuming that's not on a public roadway. Does that matter?
Well, the case law definition of operation applied to both. I know that State versus McGlone was private property. Gill and Cleary, I think, were roads or highways. Was that what you're?
Yes. Yes.
Yeah. So the case law definition of operation, the very broad definition, has been held to apply to both instances.
Counsel, doesn't the distinction here, the crux of the issue is whether or not alcohol is involved, whether or not someone is intoxicated, and the charges related to that. That's the distinction that legislature was trying to make, because driving under a suspension could have nothing to do with an alcohol consumption. You could have your license suspended for a variety of reasons, right?
That's correct.
All right. So, but the other offenses have to do with endangering the public because you're intoxicated, whether you're requiring that car to be in a position where it could endanger someone. And that doesn't apply to simply having a license suspension under the circumstances that Ms. Wilson found herself in.
I agree. I think that the purpose, the case law definition of operation was purpose driven, and it was addressing the risk to the public presented by intoxicated drivers. And you don't have that risk presented with respect to the offense of operating a vehicle under an OVI suspension. And I think that should guide the court in making a choice as to whether to apply the statutory definition or the case law definition. I think it's also important that the name of the offense is also important. Just about every criminal offense and traffic offense in Ohio, the statute will actually name the offense. And I think the fact that they named it driving under OVI suspension as opposed to operating under OVI suspension should be attributed a lot of meaning. That contextual analysis as a rule of construction requires a court to attribute validity and effectiveness to every term in the entire statute. And I think that when you call this offense driving under OVI suspension, it means something. It means that the person's actually driving a car, the common idea of what driving means. And I think that should guide the court most of all, in my opinion, to guide the court to read together the statute 451014 and 451101HHH to arrive at the meaning that in order to violate driving under OVI suspension, you have to actually move the vehicle, either at some time in the past or when you're caught. So if there are no further,
this was an OVI suspension, correct?
This was an OVI suspension, Your Honor.
So couldn't the legislature say we don't want them even starting the car?
They could have done that. They could have differentiated between operation and driving in the statute, but they didn't do it. I think I answered. Did I answer your question? Your
Yeah,
Honor?
but I was just getting to your policy argument that it's different because suspension could be something else, but here it was an OVI suspension.
It was, yes.
Thank you.
All right, thank you. If there are no further questions, I would ask that the court would affirm the well-reasoned opinion of the Court of Appeals. Thank you.
Thank you. Counsel?
Your Honor, I'd like to just briefly talk about why I don't think the doctrine of imparted materia is applicable to this case. Just because there's a perceived ambiguity in one statute doesn't permit the reviewing court to review it as imparted materia with any statute. It can't just say plain or plainly this means that. A court applying the doctrine of imparted materia essentially is asked to construe two statutes. It must do so in a way that gives reasonable effect to the terms of both statutes. And I just don't see how there's any way to reasonably construe 4511-01-HHH to say that it applies somewhere where it explicitly does not. I also talk about in my reply brief that where a statute is unambiguous, the doctrine of imparted materia is inappropriate. So all of that is to say, Your Honors, there are rules for applying imparted materia, and I don't see how you can apply that in this case without breaking those rules. The other thing as well, I'd like to...
Mr. Vogt, I wanted to also ask you, get your opinion on this. So do you think that Clary and Gill have been essentially superseded by statute? And to what extent do we go back and rely on them if in fact they have in fact been superseded? Can we?
Your Honor, you can go back and rely on them because they have been superseded in statute, but only as applied to chapters 4511-01, 4511 and 4513. So because the preamble to 4511-01, that definition of operate, is narrowed to those two chapters, I think the court is still permitted to rely on Cleary, Gill, and other places.
Thank you.
Unless there are any additional questions, we ask that this court reverse the first district and remand this case to decide whether the state presented sufficient evidence of operation pursuant to Cleary, Gill.
Thank you. Thank you, gentlemen. We'll take the matter under advisement. You'll be notified of our decision. Marshall, will you call a 10-minute recess?
The court will now take a 10-minute recess.